When I heard that Gideon versus Wainwright was going to be featured for the day's luncheon, I thought it was very important that we all attend. There are very few Supreme Court cases that have impacted our legal community as much as Gideon versus Wainwright. And Professor Jacobs, on behalf of all of the judges, we appreciate you being here. We look forward to your presentation. Personally, this decision impacted me because I had an opportunity to work at the Public Defender's Office as a result, ultimately. And I think Judge Dubinsky and Judge Dunnigan also worked at the Public Defender's Office as a direct result of the decision in that case. I also want to emphasize, while I have this opportunity, the importance of legal counsel. And so whenever I have an opportunity to address lawyers, the first thing I want to do is thank you for the pro bono work that you've done. Thank you for your volunteer legal services that you've done through the Manatee County Bar Association, and I hope that you are inspired to continue such after this presentation. So thank you and welcome again, Professor Jacobs.
Boy, oh boy, what a great pleasure it is to introduce Professor Jacob. Professor, thank you so much for being here today. Professor Bruce Jacob is from the Stetson University College of Law, where he serves as Dean Emeritus and Professor of Law. As a young lawyer, Professor Jacob saw firsthand how the United States Supreme Court can change the law of the land. Professor Jacob is originally from Chicago, but he grew up in Sarasota. He graduated from Florida State University before graduating from Stetson College of Law. After several months in private practice in Sarasota and 6 months in the Army, Professor Jacob joined the Florida Attorney General's office. After just 2 years of practice at age 26 years of age, he was assigned the job of drafting the response brief in Gideon v. Cochran, which later became Gideon v. Wainwright. While Gideon was making its way to the Supreme Court, Professor Jacob left employment with the state of Florida and went into private practice, but he continued to work for the state on Gideon. After working all week on his other private cases, he would spend weekends on the Gideon case. To do this, he and his wife would drive from Bartow to the law library in St. Petersburg, but more often further to Tallahassee, where the Supreme Court had a more extensive library at that time. At 27 years old, Professor Jacob argued the state of Florida's position at the United States Supreme Court. After the Supreme Court's decision, Mr. Jacob went on to be a champion for prisoners' rights, defending incarcerated inmates and establishing programs for their defense. He has served as professor at many law schools, including Emory, Ohio State, Mercer, and Harvard. Dean Jacob served as Dean of Stetson College of Law from 1981 to 1994. Please join me in giving a very warm welcome to Professor Dean Jacob. Thank you. We're going to help you with distributing this. Okay.
Well, thank you very much, Paul. Thank you for that very, very kind introduction. And good afternoon, everybody. I want to thank Judge Gilbert Smith and your entire Bar Association for inviting me to be here today. I appreciate the opportunity to meet with many of you before the speech. I've had the opportunity to meet two of my former students. It was great seeing them. And a very special surprise to see Ernest Smith. We were in the class of 1953 at Sarasota High together. What's that? Ernest Marshall. I'm sorry. Anyway, Ernie and I played football together against Manatee High. It's been a long time since I was involved in this case, but it still seems like just yesterday to me. My memories of being the lawyer for the state of Florida are still quite vivid. I can remember almost everything that happened during that year that I was working on the case, and I enjoy talking with lawyers about it and answering questions that you have about the case. The case began in 1961. Here it is. In the Bay Harbor Poolroom near Panama City, a few miles east of downtown Panama City. A breaking and entering took place in the Bay Harbor Poolroom, which was just outside the gates of a large paper mill. And Clarence Earl Gideon, who lived in a rooming house across the street, was arrested later that morning and charged with this crime. When he appeared in court, he pled not guilty and he asked for a lawyer. You saw the film a little bit earlier. But the judge did not appoint counsel. The rule of Betts versus Brady, which was the Supreme Court rule at the time, was that the Constitution did not require the appointment of counsel in every single criminal case, every single felony case. The judge said, as you saw in the film, only in capital cases at the time was the court required to appoint counsel in Florida. The Betts versus Brady decision, however, court did say in that case that counsel should be appointed whenever there was a special circumstance present in the case which would make it difficult for the defendant to get a fair trial without the appointment of counsel. This was required as a matter of due process in Betts versus Brady. If a defendant was young, was inexperienced, or illiterate, for example, this would constitute a special circumstance that would require that counsel be appointed in that case. Gideon, however, was about 50 years old. He had had previous experiences in criminal courts, and he seemed to be of average intelligence, and the judge did not think that it was necessary to appoint counsel in that case. The judge was Judge McCrary. Oops, supposed to be. Well, this is Gideon. And then Judge McCrary was the judge who refused to appoint counsel. At his trial, Gideon cross-examined the witnesses for the prosecution. He was advised that he did not have to take the stand, and he did not take the stand in his own behalf. He was convicted, and between the time of the conviction and the day of sentencing, the probation office did a pre-sentence investigation report on him. I bought copies of that report, and we'll pass them around. There should be enough for everybody here. On the day of sentencing, Gideon was given a 5-year term for the crime of breaking and entering with intent to commit a misdemeanor, petty larceny. The 5-year term was based upon the fact that he had served several sentences for felonies, both state and federal, in the past. He did not take a direct appeal. He did what most Florida inmates did in those days. He filed a handwritten habeas corpus petition directly in the Florida Supreme Court. In his petition, he did not allege that any special circumstances had been present in his case. The Florida Supreme Court denied the petition for the reason that under Betts versus Brady, he was not entitled to relief unless he had alleged at least one special circumstance. Gideon then sent a handwritten certiorari petition to the United States Supreme Court. The Supreme Court asked our office, the Office of the Attorney General in Tallahassee, to provide a typewritten response to Gideon's cert petition. There were 4 of us at the time in the office, in the criminal appeals section. We did almost all of the criminal appeals and post-conviction cases for the state of Florida. Reeves Bowen, a former county judge, was the head of our section. I was the newest and the youngest and the only one of the 4 in that section who had not yet argued a case in the United States Supreme Court. And I'm sure that was one reason why I was chosen to handle Gideon. Another reason, I believe, was that Judge Bowen and I had worked on 2 law review articles together, and he knew that I enjoyed legal research and also I liked legal history. It was March 1962 when I was assigned the case, and I was 26 at the time. I prepared and submitted the typewritten response, and then 2 months later, in early June of 1962, the Supreme Court granted Gideon's petition, and asked counsel on both sides, among other things, to argue the question of whether or not the decision of Betts versus Brady should be, quote, reconsidered. In late June of 1962, Abe Fortas was appointed to the case to represent Gideon. He was a very, very prominent Washington, D.C. lawyer. In September 1962, while doing research for the case and awaiting the brief from Abe Fortas, I changed jobs, moving from Tallahassee to Bartow to work for the firm that was then called Holland, Beavis & Smith. It's now known as Holland & Knight, and today has offices in Tampa and other cities in the United States and also overseas. I was the 14th lawyer in the firm. It was one of the largest firms in Florida at the time. The people in Bartow called it, or referred to it as the law factory, because a firm that large, 14 lawyers at that time, was considered very, very large. I asked the Attorney General, Richard Irvin, and my boss, Judge Bowen, if it would be all right for me to continue handling the Gideon case after moving to the Holland firm, and they all agreed. And also Chesterfield Smith of the Holland firm said it would be all right and agreed to allow me to work on the case at the Holland firm. Ann and I got married at the time of the move to Bartow in early September of 1962, and throughout that fall we worked on the brief in the case. There's a picture of us getting married. The case was then called Gideon versus Cochran, and that was because H.G. Cochran was the director of the State Division of Corrections at the time. In the evenings, Ann and I would work in the law firm's library in Bartow, or we'd walk a couple of blocks to the historic Polk County Courthouse. We had been given a key to the courthouse, and we would go inside and walk up to the third floor and work on that library. On weekends, as Paul said, we would drive to the Stetson Law School in St. Pete or to Tallahassee to the Supreme Court Library to do research. That library had a lot of historical and old English materials that I needed for my research. The Supreme Court Assistant Clerk and Librarian, Agatha Thursby, gave us a key to the front door of the Supreme Court building. We worked in the library in the basement where the historical English materials were kept. I would point out excerpts from cases that I needed, and Ann would copy them down on note cards. When she provided the key to the Supreme Court building, front door of the Supreme Court building, Mrs. Thursby said, "Just be sure to lock the door when you leave." Abe Fortas' brief was filed in November 1962, and that meant that our brief was due 30 days later, shortly before Christmas. Our brief was typed by Ann at home. My personal belief was that every defendant in a non-capital case should have an attorney, and I was happy with the result in Gideon on that issue, but there were other issues in the case. One was whether the states should make the decision through legislation or court rule rather than having the United States Supreme Court make that decision for the states. Another issue was whether a decision overruling Betts versus Brady should be prospective or retroactive in effect. Still another was which part of the Constitution should be the basis for overturning Betts versus Brady. Should it be the Equal Protection Clause? Should it be the Due Process Clause? The arguments in Gideon were set for January of 1963. We were given an hour and a half. I asked George Mentz, the Assistant Attorney General of Alabama, who had written an amicus brief on our behalf, supporting us, to take a half hour, and I had an hour. On the day before our arguments were scheduled, the justices filed in, and the first thing they did was to swear in new members. George Mentz moved my admission, and Chief Justice Earl Warren welcomed me. He leaned far out over the bench, it seemed to me, and said, "Welcome, Mr. Jacob, to the bar of our court." At that time, I was 27 and had been a member of the Florida Bar for just barely 3 years, which was what was needed to be admitted to practice before the United States Supreme Court. Here's what I looked like at the time I appeared in the Supreme Court at approximately the same time. I'm always amazed when I see this at how little I've changed in 53 years. On the first day, the justices read their opinions. One of my impressions on that first day was the informality of the court. I had expected a lot of ceremony and formality, but the atmosphere was quite informal. On January 15th, the second day we were there, the arguments began and the court became very, very businesslike. It was no longer informal, but very businesslike. There are backup or ready tables behind the tables of the lawyers arguing a case. I was seated at the backup table behind the lawyer for the antitrust case that was heard before our case, the White Motor Company case. The lawyers in that case, on both sides, Archibald Cox was Solicitor General for the United States. The lawyers in that case were wearing morning coats and tails. I was wearing my dark blue suit because the clerk's office had told me in a phone conversation that it was okay to wear a dark suit. No one was seated at the ready table to my right, on the right side. I was on the left facing the court. But as the case before ours ended, Abe Fortas appeared and sat at that table. Soon after he began talking, the noon hour arrived and the court recessed for lunch. Fortas and I were left downstairs, one floor beneath the level of the Supreme Court. We introduced ourselves. We hadn't met before, and we sat at a very small table across from each other, just a tiny little table. We were the only people in the room, other than the waiter who would come in from time to time, but wasn't there the entire time. Fortas began by apologizing. He and his wife had sent an invitation to my wife Ann and me to come to their home on the previous Sunday evening, along with the lawyers in the companion cases to Gideon. Those cases were Douglas versus California, Draper versus Washington, and Lane versus Brown. The invitation had gone to Tallahassee, but I was in Bartow and we hadn't received it. During most of our lunch, he talked about Justice Black, how much he admired Justice Black. He talked about the election case arising in Texas when Lyndon Johnson was running for the United States Senate for the first time. There had been a runoff between the two Democratic Party candidates, Lyndon Johnson and Coke Stevenson. Johnson had won by 87 votes, but a ballot box in one county had 202 votes for Johnson, all in the same ink and the same handwriting. The box with the 202 ballots disappeared. Stevenson alleged vote fraud and went to federal court. The federal judge invalidated the vote, but Fortas, representing Lyndon Johnson, went to Justice Black as the circuit judge for the Fifth Circuit in Black's chambers in the Supreme Court building and convinced Black that the federal courts had no jurisdiction to interfere in a state election. So Lyndon Johnson won. We returned from lunch, and Fortas resumed his argument. By this time, the spectator section was empty except for one person, my wife, Ann. It seems strange that for a case of this magnitude, there was only one person in the audience. One other non-lawyer was present, and that was Anthony Lewis, who was the reporter for the New York Times in the Supreme Court and the later author of Gideon's Trumpet. He was allowed to sit with his portable typewriter far to my left inside the bar as I faced the bench. And by the way, when you watch the afternoon portion of the argument, the courtroom is packed. However, that wasn't true. Ann was the only person in the courtroom. When you see the movie, it's packed, but it really wasn't. When Fortas finished, it became my turn to argue. I stepped before the podium, and my first impression was that I was down in a pit. These justices seemed to be sitting much higher above me than judges in the Florida appellate courts. Also, they were spread out very far to my left and to my right in comparison with Florida appellate courts where the judges sat closer together. Also, the speaker's podium seemed closer to the bench than was the case in Florida appellate courts. The podium had lights on it. There was a green light, a yellow light, and then a red light for when the speaker was supposed to stop. I began to make my prepared argument, but the moment I began, there were questions. The intensity level was very high. The justices took a much more active part in questioning than judges in the Florida appellate courts. I read the transcript of the argument and counted 92 questions or interruptions during my argument. Every justice except Justice Douglas asked at least one question or interrupted at least once. The questions and the comments from the judges came very, very fast. One judge would ask a question, I would begin to answer, and then another justice would break in with a question. I would try to remember that question as I tried to finish my answer to the first question, and then as I was doing that, a third justice would ask a question or make a comment. After the case was argued, H.G. Cochran stepped down as the head of the Division of Corrections. It's now called the Department, but then was the Division of Corrections. Louie Wainwright then became the director. I wrote the court and informed them of this. I did not receive an answer, but when the opinion was released on March 18th of '63, The name of the case had been changed from Gideon versus Cochran to Gideon versus Wainwright. And I've got a picture of Louie Wainwright. There was a newspaper strike on at the time, and Anthony Lewis, the reporter for the New York Times, phoned and asked to interview Ann and me. We met him at the Hawaiian Village Motel near the old Tampa airport. He told us that he decided to write the book Gideon's Trumpet because he had nothing to do during that strike. The decision in Gideon was announced on March 18th, 1963. Gideon had won. Betts versus Brady was overruled. The Sixth Amendment's right to counsel provision, which previously had applied only in federal courts, now was incorporated into the 14th Amendment and made applicable in state courts. The Gideon opinion contained no discussion of whether the holding should apply in misdemeanor cases. That issue was dealt with in Argersinger versus Hamlin 9 years later. Also, the opinion did not specify whether the decision in Gideon was based on the Due Process Clause or the Equal Protection Clause. The opinion merely said we're basing our decision on the 14th Amendment, which, of course, contains both of those clauses. The case began the federalization of criminal procedure. The federal model had now become the state model, the national model. Federal case law interpreting the 4th, 5th, 6th, and 8th Amendments has since become binding on the states. The case went back to Panama City for a second trial. Gideon now had a lawyer, a very good lawyer named Fred Turner, and Gideon was acquitted at that second trial. Here's Fred Turner. He was able to persuade the jurors that a group of young men returning from an all-night party in Apalachicola might have been responsible for the break-in of the pool room. One of the questions I often am asked is whether Gideon committed the crime. He was acquitted at the second trial, but was he really innocent? Or was he acquitted through the skill of his lawyer, Fred Turner? In the pre-sentence investigation report, which we handed out, Gideon admitted that he had been in the Bay Harbor pool room and had taken the items he was charged with taking. He admitted he was guilty of petty larceny, but said that the door had been open when he entered. Therefore, he should not be guilty of the greater crime of breaking and entering with intent to commit a misdemeanor, but merely petty larceny, which was a much lesser offense. Turner, before the second trial, tried to get Gideon to accept a favorable plea bargain offered by the prosecution. To the credit of the Florida legislature, immediately after the Supreme Court decided Gideon, it enacted the statute which created the public defender offices in each of the circuits in Florida. When the Florida legislature adopted that statute, it included a provision that allowed private lawyers to volunteer to become unpaid special assistant public defenders. On the day that that law went into effect, I went to the circuit court in Bartow and signed up under that provision, and then was appointed to handle several cases as a Florida special assistant public defender before I left practice to become a law teacher. 53 years have passed since the court made its decision in Gideon, but have we made 53 years worth of progress since then? The answer clearly is no. Caseloads of public defenders throughout the country are excessive. Under these conditions, effective representation is just not possible. One problem is that a public defender has only enough time to spend 5 or 10 minutes with a client before allowing that client to plead guilty, even though a paid lawyer might spend hours on the case before allowing the client to plead guilty. In the report of the National Right to Counsel Committee of the Constitution Project in 2009, which is entitled Justice Denied, America's Continuing Neglect of Our Constitutional Right to Counsel, that committee says, and I'm quoting, "Today, in criminal proceedings, sometimes counsel is not provided at all, and it often is supplied in ways that make a mockery of the great promise of the Gideon decision and the Supreme Court's soaring rhetoric. Throughout the United States, indigent defense systems are struggling due to funding shortfalls, excessive caseloads, and a host of other problems. Many are truly failing." Well, that's the end of the quote. Public defenders should have lighter caseloads. We need a lot more public defenders throughout the country. We waited 50 years, and I sincerely hope we will not have to wait another 50 years for the ideals of the Gideon case to be fully realized. Let me close my remarks by returning to Panama City and the Gideon case. In September 2000, Fred Turner, who, by the way, became a good friend for several years before he died in 2003, he drove Ann and me to the site of the Bay Harbor Poolroom. The paper mill was still there, but the pool room and the buildings in the small community of Bay Harbor all had been demolished. All that was left were the streets and the foundations of the buildings. Gideon is dead. Abe Fortas is dead. No member of the Supreme Court who was involved in the case is still alive. Looking back over these past 50 years, 53 years, I realized that my interest in law teaching was due largely to my involvement in the Gideon case. It got me interested in providing legal help to indigents. I've started legal programs for indigent defendants and for prison inmates in several states at several law schools, at Emory in Georgia, Harvard Law School in Massachusetts, Ohio State in Ohio, and of course at Stetson here in Florida. Even now I do pro bono work for prison inmates and criminal defendants. Over a period of 50 years, 53 years, I've handled many pro bono cases for criminal defendants and prison inmates, and just about every one of these has been incredibly interesting. Clearly, however, the most interesting and most memorable of all the cases that I worked on during my career was being the lawyer for the state in Gideon versus Wainwright. Thank you very much.
What an honor, Dean Jacob. You've enriched the profession so much, and we just thank you for speaking this afternoon with us. I'd like to introduce James Horn, the president of the Young Lawyers Division. If we could ask you to come back up again.
Thank you so much, Dean Jacobs, for being here today and sharing all your experiences on probably one of the most important cases in U.S. legal history. I'd just like to present you a small gift from the Manatee County Bar Association.
It's not a small gift. Thank you
Yeah,
very much.
yeah, and please come back and visit us
Okay.
again soon. Thank you so much.
Should I open it?
Yes, yeah, open it so we can see. Okay.
Oh my gosh. Wow. Thank you so much.
Oh, you're very welcome. You're very welcome.
Hello, this is Gilbert Smith, and I'm here today with Professor Bruce Jacob, and we're going to talk a little bit about his experiences when he represented the state of Florida in Gideon versus Wainwright. Professor Jacob is a professor and dean at Stetson College of Law, and we had him speak to the Bar Association today in Manatee County, and now would like to visit with him on some of the things about the Gideon versus Wainwright case. Good afternoon.
Good afternoon,
Professor Jacob.
Judge.
Okay, good to have you, and thank you so much for talking to us about the background of the Gideon versus Wainwright case, which, as you indicated before, was called Gideon versus Cochran at the time.
Right.
So it was very interesting to hear about some of the background of the crime that Gideon was accused of,
Mm-hmm.
and that occurred in where, Palm County?
It was in Panama City. I forget the name of the county, but anyway, it was in Panama City, in a small town that was just east of downtown Panama City, about 5 miles east, called Bay Harbor. Very tiny town, just one street and buildings on both sides.
Okay, and as a young attorney, you were with the Attorney General's office at that time?
Yes.
Okay, and tell me a little bit about the case coming into the office.
Well, we received a letter from the Supreme Court telling us, I was in the criminal appeals section of the office, of the Attorney General's office. We received a letter from the United States Supreme Court with a copy of a certiorari petition that had been filed by Gideon, by Clarence Earl Gideon, and the Supreme Court asked us to file a typewritten response. That was how we got into the case.
Okay, and at that time you had only been there, what, a couple of years?
A couple of years, about 2 years.
And so you had the opportunity to take this case given to you, correct?
Mm-hmm.
So you worked with some really interesting people at the Attorney General's office, didn't you?
Yes.
One in particular was a gentleman that you describe in a law review article that I saw, that where you worked with a lot on actually writing some law review articles, but also could consult with him on these type of cases.
He was my boss.
Who was that?
He was my boss.
And who was
Reeves Bowen?
Reeves Bowen.
And he was a great lawyer, and whenever he assigned a case to me, he'd have me read the files, read the transcripts, and then come back to talk with him, and we'd go over it, and he'd say, well, you got to go back and do some more. And I learned how to read transcript very carefully, and anyway, he was a terrific teacher. Those sessions with him were like a course on jurisprudence.
Right.
Great lawyer.
So I was interested at the time in the state of Florida. There was actually some counties had set up what would be a public defender type situation. One of them was where? Dade County?
Dade County. Jacksonville had an appointed counsel system. A law had just been passed to establish a public defender office in Hillsborough County.
And I guess that was based on population, wasn't it?
That was a Population Act.
That was a Population Act, and that's what I wanted to clarify. There was, in fact, a law called the Population Act.
Creating that office.
Right.
And even Pinellas had a very small office, so maybe one lawyer, 2 lawyers. So there were at least 4 counties that I'm aware of that had some sort of public defender office or an office to provide help to indigent defendants.
So the law at that time did not require a court to appoint counsel unless it was a capital offense.
Yeah.
Or there were special circumstances.
Right, there had to be some special circumstance. Either the defendant was extremely young, or didn't have much educational background, or perhaps English was not his first language. In cases like that, the judge was required, under Betts versus Brady, the previous case, to assign counsel.
Okay, and there that was actually the discretion that some judges used to not allow an attorney for misdemeanor cases.
Yeah, misdemeanors. I don't think anybody thought that judges had to be appointed for misdemeanors.
Right.
That was, we're talking about non-capital felonies. Already, the state laws required appointment of counsel in capital cases, but the question was whether counsel should be appointed in non-capital felonies, and that was counsel only had to be appointed if there was a special circumstance, according to Betts versus Brady.
So throughout the United States, the states were doing things different ways, were they not?
Right.
And so it wasn't consistent throughout.
Not at all. Minnesota, I think, which is a smaller population state, was even providing counsel, I think, in certain misdemeanor cases. I think that may have been the only. Maybe a couple other states were providing some counsel in misdemeanor cases, but I think about two-thirds of the state at that time were providing some sort of counsel in non-capital felony cases.
So the Attorney General of Florida at that time that you worked there was who?
Richard Urban.
Okay, and I recall reading that while this case was going on, that actually I think you wrote the letter, but didn't the Attorney General sign a letter that went to other Attorney Generals to see what
We wrote
their
to all the
positions
Attorney
were?
Generals. The main purpose was to make sure they knew this case was coming, because we were pretty sure that once this case was decided, the Supreme Court would require counsel in misdemeanors, and we knew that there were states that did not want that to happen. So we just wanted to make sure everybody knew what was coming at the Supreme Court level.
Yeah, and I thought that was really interesting how that turned out and the responses you were getting back.
Yeah.
So it wasn't exactly, I think, what you thought you were going to get back
Yeah.
at times, but
We really didn't know, and the main point was to make sure everybody was notified. We just want to make sure everybody knew what was happening. We weren't really expecting. I think we urged them to file an amicus brief if they wanted to, but we weren't sure what we were going to get out of it, and we weren't all that surprised that most of I think 20 states filed an amicus brief on the other side. I think only 2 states filed a brief on our behalf.
so it was really interesting. The landscape of the people that were incarcerated at that time in the state prison system was 8,000 or 9,000 prisoners.
Only a tenth or less of the population in the prisons that we now have. We have over 100,000, I think, in prisons in Florida today. and it was less than 10,000.
So I saw that you did actually a survey.
Yes.
And you went to the Division of Corrections at that time.
Yes.
And you did a survey to sort of find out
Yeah.
in the process of people having their claims or their offenses adjudicated, who was represented and who wasn't.
Right. The Division of Corrections did the study for us. I think at that time there was, they got something like, they they were able to see the files or interview something like 6,000 or 6,500 inmates. I think there only were, as you said, maybe 8,000 inmates in Florida. So, you know, a very high percentage. They were able to find out who was represented out of a pretty high percentage of all the inmates in Florida. What they found was about 65% of Florida inmates had not been represented. Those pleading guilty and those not pleading guilty, only about 35% had been represented by counsel.
And so part of the argument that you were going to make to the Supreme Court had to do with the fact of whether or not, as you indicated earlier, whether this should be retroactive.
Right. If it were retroactive, we knew that many inmates would be released all at once, and so we were hoping that the court would make it prospective only. And doing that study in the prisons, we wanted the court to know, we figured they would want to know that statistic, and also we were hoping that that would make them pause before making the decision retroactive.
So at that time, in fact, after the Gideon decision, there were a few cases that clarified Gideon, were there not, with respect to how the court was to deal with.
Not as many as you would expect.
Right.
For example, I thought the court would issue opinions telling us how to go about deciding whether an inmate was indigent or not. They didn't do that. I don't think they, even today, they haven't done that. We really expected more decisions. But of course, eventually Argersinger was decided. They decided a case about 4 or 5 years later that said that Gideon was retroactive. It took about 4 or 5 years to make that decision, 9 years to decide that in misdemeanors you were entitled to have counsel if the punishment was time in jail.
And so the Florida legislature had to get to work after that decision.
The Florida legislature, much to their credit, got to work immediately.
They did.
I think in May of 1963, less than 2 months after the decision, they passed this statewide public defender law, setting up a defender office in every circuit. You know, I don't think any state in the country had gone that far.
They hadn't, so you think Florida was ahead.
Florida immediately was way ahead of everybody else.
So you indicated that after the decision, you were back in Bartow, that you went down to the office and signed up.
Yeah, I signed up and got assigned to cases as a...
As pro bono?
Yes.
Okay.
Yes.
And
Actually, the Gideon case was pro bono too. I got a letter from somebody asking me, was I paid for this? I never even occurred to me that I would ask to be paid for when I moved to Bartow.
Oh, is that right?
Yeah, I even paid my own airfare to Washington, D.C.
So that was all on you.
Pro bono, yeah.
Really?
Sure.
So the whole case.
I would never have even thought of asking the Attorney General to pay for any of that.
So the firm you were with was a pretty special firm with Spessard Holland,
Yes.
who had been the governor of Florida and a U.S. senator.
Right.
And they were understanding with you taking
Yes.
on this case
they
and
were.
continuing.
Yes, they were. I said I'll only work on it in weekends, nights, and Chesterfield Smith said, Bruce, work on it as much as you want. They would have typed the brief. I just had my wife type the brief, and I worked only nights and weekends. But Chesterfield Smith wanted me to use the firm's resources. I could have if I had wanted to.
And you actually practiced with some other pretty special lawyers. Steve Grimes was another one. Henry Kittleson.
Yes.
And
Bill Henry.
Bill Henry.
Yeah.
Yeah. And
Warren Hall. I don't know if you knew
who?
Warren Hall.
Yes. Okay.
Was a great lawyer too.
And
And with Chesterfield, I worked with Chesterfield on some
cases.
Yeah.
And so that was a pretty special time and really led you on what you were going to do by working on this case.
Mm-hmm.
And so talk a little bit about that. Let's talk about this first. Before we leave, talk about what surprised you about how the court decided this case on terms of due process.
They didn't really decide on due process. They just said 14th Amendment. And I'm not even sure today which either whether it was due process or equal protection that they used as the basis for the decision. We argued both, and it was very difficult to justify ruling in our behalf using either of those portions of the 14th Amendment. And I think that's why the court just ducked the whole issue altogether and just said 14th Amendment. I was surprised. One of the things that surprised me was how short the opinion was. To me, the case was mammoth. It involved so many issues, retroactivity, you know, so many different issues. But the opinion was only, what, 3 pages or 4? Very short opinion. I thought there were a lot of issues they could have, retroactivity, for example, I thought they should have dealt with those issues, but they didn't. Took a long time to get around to deciding those issues. So I was surprised by that. Trying to think what else.
So the impact of this decision had such an impact on every state,
Yes.
and more so than just in the judiciary. It really had an impact on budgets. It had an
Sure.
impact on government as a whole
Yeah.
in terms of creating an entire new department.
Yeah, I thought they should have, much earlier than they did, should have talked about what kind of representation should be given, whether 5 minutes spent talking about the case and then pleading the client guilty was adequate or not. They should have, as I said, should have defined what is meant by indigency and given us some guidance on how to determine whether a person is indigent and therefore entitled to counsel. I don't think they gave us a whole lot of information that we really needed right at the outset. I thought they could have done a lot more instead of that very brief opinion.
Right. So how long did you practice law in private practice?
I started in '59 and left practice in '65. So I
Okay.
guess 6 years. But then since then I never stopped practicing because I had a break and I went to Harvard Law School to do graduate work, and I worked in the public defender was a Harvard Law School defender office for a year practicing law. When I was at Ohio State, I was the head of the clinic, director of the clinic, and I always had a caseload of maybe 45 cases that I was working on with students. So even though I was also teaching criminal law and criminal procedure, I for all intents and purposes, was practicing
So you
almost
continued to
full-time.
practice
Yeah.
the whole time that
And
you...
even now, just yesterday, I wrote several letters to inmates giving them advice on their cases. So I never really stopped practicing.
And so you've gone into the academic world along with practicing
Yeah.
law, and you have been teaching. What courses do you teach?
I've taught over 20 courses since I
Throughout your career.
Throughout my career. Right now, I'm teaching administrative law, criminal procedure, and constitutional law. But anyway, the nice thing is that since I'm a law teacher, I have a salary, so I can work on these cases without any fee. And I don't think I've never gotten a fee for a criminal case or a case involving an inmate. But I'm able to do all this pro bono work because I'm teaching and using students to help me, giving students some experience.
So the number of, and you just indicated the number of inmates is so high now in the state of Florida.
right.
There's such a need for representation, is there not?
Mm-hmm.
And with the public defenders, each have heavy caseloads.
I don't think public defenders are allowed to handle post-conviction cases of inmates. They're so busy just handling trials.
Right.
And there's so many inmates who have good cases that should be post-conviction cases that should be filed, but they don't have the knowledge to do a good job. They file something, but it doesn't really hit the issues that are really relevant. And so we try to help as many as we can.
Are you doing it on a state level or on a federal?
Right now, it's almost always. I have had some letters from inmates in Virginia and places like that, but 95% are from Florida inmates right now. But when I taught at Emory, I set up a program at the Atlanta Penitentiary, the U.S. Penitentiary in Atlanta, and within 2 weeks after we had put application forms in the prison library, we had 750 applications, and a couple weeks later we had 900.
Wow.
I was the only lawyer with 53 students. In order to handle the load, we got two of the very best jailhouse lawyers out of the Atlanta Penitentiary and set them to work supervising students. So if you went to the Emory Law School library, you'd see a former bank robber sitting next to a student poring over
Right.
transcripts, trying to
Right.
help an inmate with his case. I also set up a program in Massachusetts. When I was a graduate student at Harvard, I set up a program. I think both those programs are still operating. One for all the Massachusetts prisons, and the other one, of course, the U.S. Penitentiary in Atlanta, I think, closed down. So I'm not entirely sure that the Emory program is still going, or in which prisons it's now operating, if it still is operating.
So, as you know, as smart as someone is, and that if someone is charged with a crime, they need to have representation.
Right.
And as maybe even somebody sophisticated still needs not to represent themselves.
Sure. No, everybody, the story about Clarence saying that I never want to represent myself.
Right. And so, but what we have, of course, are many people that are incarcerated or charged with crimes. They're not sophisticated
Right.
to the point that they even understand that. So it's the service of providing representation is such an important part of being in the judicial system or in the criminal justice system.
And we're able to screen out if an inmate doesn't really have a good case at all. We're able to tell them, look, you just don't have anything, and so that prevents inmates from filing frivolous kinds of cases. I got into this helping inmates at Emory when I first started teaching criminal law there. The U.S. District Judge downtown, Frank Hooper, called me and said, "Can you come down and see me?" He appointed me to a case challenging rules of the prison on constitutional grounds, swore me in to practice in federal courts in Georgia. And he said that, and then after that case was over, that case involved whether or not jailhouse lawyers should be allowed to practice in the prison. We won the case. After that, he and the other judge in downtown Atlanta, Judge Edenfield, called me in and they said, we really could use the help of you and your students, because we get these petitions constantly from federal inmates. We can't make heads or tails of them. We don't know what they're saying. It sure would help if you and your students would go out there and meet with this person, figure out what they really are saying, and maybe redraft the petition,
Right.
or advise the inmate that he really doesn't have a good case at all, and it probably shouldn't be filed at all. So that's really how I got started in helping inmates.
And it's been satisfying.
Oh, I like doing it. It's to me it's a lot of fun, and plus I try to get students involved, and they seem to get a lot out of. They really enjoy working on a real case.
Right, practical experience
Yeah.
they would get at that manner. Well, I'm going to have to cover this because from the very beginning you talked about how much help your wife was.
Yes.
So tell me about, from the very beginning, how supportive she was.
Well, she was terrific. We had just gotten married, then moved to Bartow, and I of course had to work. I was doing the research and writing sections of the brief, and she would type each section. We bought a used typewriter from Holland and Knight, and she would type each section, and I'd edit that section. She'd retype it while I was working on another section, and then of course she went to the library up in Tallahassee and the Stetson Library with me, and the library at the old courthouse in Bartow. And she'd copy things on notes. I'd say, "Could you copy this?" And she'd copy it.
So did they have copy machines?
No, there was no Xeroxing.
There was no Xerox,
Yeah,
no copy machine.
No such thing. Or maybe it had been discovered, but or they had begun producing Xerox machines, but we certainly didn't have any until about '64.
And so all these cases that you would go through, that your wife, would she be writing notes and writing
She'd
down?
copy the notes. And when we went to Washington, D.C., when we flew, of course there was no Xerox things, and I had about 30 cases that I wanted to take with me.
Right.
So he took a big suitcase full of about 30 law books.
Is that right?
And on the way back in those days, the airlines would charge you for if you were overweight. and we had to pay a $50 fee on the way back, and $50 in those days was like $500
Right,
today.
right,
So,
right. And that was pro bono.
Yeah, yes.
So you really couldn't have done this without her, could you?
No, I couldn't have done it, and I keep telling her to come whenever I give a speech, because people want to see her. I mean, she was
Right.
just, and she's come to some of them, but she usually doesn't come. But she was a very big part of the case.
Well, so I want to finish this up by just talking about what you indicated earlier, and that is that your experience in working on and preparing and arguing this case in the Supreme Court really encouraged you to do what you did the rest of your life.
Yeah, it got me on the track to go into law teaching. It had a lot to do with my wanting to be. I thought about being a law teacher earlier, but working on this case and some of the other things I worked on in the Attorney General's office got me thinking more in terms of wanting to teach. So that had a lot to do with, and also had a lot to do with my going into criminal law, mainly criminal law and criminal procedure and constitutional law. I've taught a lot of other things, tax law, state administrative law, just a lot of different courses.
Well, it seems like the exercise of all that work that you did really did pay off in terms of really motivating you to what you were going to do the rest of your life.
Yes, that's true. That's certainly true.
So I want to thank you for being here today to the Manatee County Bar Association. I want to thank you for sitting down with me and talking a little bit about your experiences as the attorney who represented the state of Florida in the Gideon versus Wainwright case. Thank you.
Thank you. Thanks
very much for
talking,
being here.
Judge. Thanks for inviting me. Appreciate
Okay,
it.
and thank you everyone for joining us today. It was great to have Professor Bruce Jacob here, and we hope he'll come back. Thank you.
Okay.